And I am from Massachusetts, but I'm going for the Astros. Because I grew up when the Red Sox lost all the time, and I like it when they finally won. Now I'm kind of like, well, they won. Now give someone else a chance. All right, jury charges. How many of you think of jury charges before the court reporter brings it in that she printed out from the charge bank? I want you to think about it. I want you to make your own. When I officed with Mac, he began trial backwards. He'd always print out the jury charge and start that way. If you don't have at least a proposed charge or something you're interested in, you can't be telling me that the Harris County Charge Bank is all that great. It's not. I raised an objection. It was one paragraph, one sentence, 242 words was the application paragraph. Who can understand a 242-word sentence? Right? Nobody. So have your own. Make objections. All right. Maybe you need an hour. Maybe 30 minutes isn't quite enough if we're going to do all of this. But if you give an hour to thinking about it, and you change all your objections to constitutional objections, you're in a better position than you were 10 minutes ago. Trust me. Voir dire, and I love Casey. She's out there picking a jury, and I can just see they would love her. The few juries I've picked, I can't say they were enamored of me. They were hoping I would stop talking soon, but that's you all too. I get it. All right, so this is what you think about voir dire. I'm going to connect, and I have my theory of the case, and I'm going to put some psychodrama on you and put myself in your position. You know how that works, right? Right, I'm going to psychodrama you, something like that. So this is what you think about voir dire. And this is what I think, the judge, they're shutting him down, the judge is saying crazy stuff, and they're not saying anything. Now, I'm not going to say this judge's name, Jim Wallace, but he was actually reversed for some comments he made during voir dire, 15 years ago. And what's so interesting about that is there was no objection, but it was so outrageous that even the Court of Appeals is like, no, you can't say stuff like, I'm sorry, jury panel, you have to be here. We tried to get him to plead guilty earlier, but he wouldn't do it. Right. So crazy stuff does get said, and in the rare sort of rainbow unicorn world, the court will correct it. Well, that's one time. If anybody says any crazy stuff, what are you going to say? Are you going to jump up and object? Yeah, objection, judge, you're denying my client a right to a fair trial, an impartial jury, due process. I need a mistrial, whatever. We'll talk about that. So, voir dire is actually a great place to make error, to get your case reversed. But you got to be listening, you got to be prepared. All right. Does either side have any objection to the jury? This is after you've objected to commitment questions, objected to the comments by the judge. Does either side have any objections to the jury? No. Now, do you think that waives all your prior objections? Okay, I'm going to let you believe that. It may or may not, but I want you to believe that. And so I want you to say something more like, subject to my prior objections, no objection. Something like that. Because we don't want to waive anything or give it away. Okay. Challenges for cause. I've seen this done correctly. I want to say I just recently saw it done correctly, so maybe 6 times in my life. The first person I ever saw do it correctly was Brian Benkin and Clint Greenwood. When I saw that, I was just like, I think I had to go home and rest for the day. I was so excited. It's like, oh my gosh, they actually did it right. Okay, do you ever challenge someone for cause and the judge doesn't grant it? Does that ever happen to you? Does that ever happen? And does that upset you? Do something about it. Do something about it. Make the correct objection, because just objecting isn't going to do it. This is in the paper. I'm not going to read it all to you, but it's a 6-part test. And I want you to know that one time, 23 years ago, I wrote a PDR on this very issue and researched the law in every state in the country and showed that Texas was the only one to have this outrageous, 6 parts test. Everywhere else, you just made the objection, the judge denied it, you moved on. And I wrote my PDR, and it was quickly denied. Denied. And so I went back to, back then I was working at the prison, inmate legal services back then, working in Huntsville. But the weird thing was, a couple months later, do you all know Charlie Baird, some of you, maybe over 40? Well, Judge Charlie Baird was looking for a new staff attorney, and I applied. Well, long story short, he got my resume, and he ended up hiring me, and he goes, I remember that PDR you wrote. So see, even though I lost for my client, I won for myself. But I want you to be thinking about this stuff. Okay, let's say a lawyer actually did this, but then did this. Does either side have any objection to the jury? No. Yeah, you're waiving it, possibly. So I want you to think about that. Subject to my other objections, Judge, I'm fine. And I've had questions, which I think are really good questions, from lawyers out there who say, well, what if I want to challenge for cause, and then I have to identify an objectionable juror, and then the judge is saying, are you objecting to the jury? And I have to say it right in front of the jury panel I just picked, and now they're going to be thinking, okay, go to the bench or ask judge, could we take a 10-minute break? I know some judges are against that, but there's a way to do it where you don't have to say it in front of the jury, and you can get it out there and on the record, and we're going to make it timely, specific, get our ruling, and we're going to follow the 6 steps. How many of you have asked for additional peremptory challenges? Yeah, you know what? I'm a little bit of a sports fan, and so I live my life by the words of the great one, Wayne Gretzky. Okay? You miss 100% of the shots you never take, right? So just ask for it. Yeah. You think Gretzky scored on every shot? Maybe, but we're not Gretzky. Okay, all right. An error in erroneous granting the state's challenge for cause. Do they ever grant the state's challenge for cause erroneously? Like the state's like, oh, I challenge that person for cause, that'll be granted. And you're like, yeah, I see, you're like, yeah. Well, let me tell you, that's almost impossible to win on appeal. So argue there, but know that do preserve it. Trap, timely, specific, get an objection. You can object to the final compilation of the jury, exhaust your peremptories, request additional peremptory, and make a record that the jury actually selected was not composed of qualified persons. See how the court has made that test ridiculous? And I won't bore you too much, I'm trying to stay on time, but recently we had an appellate seminar, and Justice Terry Jennings and Sharon McCallie came. And I don't want to throw you off too much, but they were saying to us, do you realize the rules of evidence are the same for criminal and civil? And I guess I realized that, but whenever I write my briefs, I'd always just look at the criminal cases. But the criminal cases they are so much stricter, like, oh, we cannot reverse a jury verdict. It's sacrosanct. But man, you let an insurance company lose, they're reversing it. So my last brief, where the lawyer only said objection, confrontation clause, which I wasn't sure if they were going to say it was constitutional or hearsay. I just cited civil cases. And then I started citing insurance company like it was a person, like capital I, capital C. We couldn't let the insurance company lose, so the Court of Appeals reversed it when they were denied the right to ask a lady whether she wore fake hair. I kid you not. But I don't want to throw you all off. I want you to focus on the Constitution, because the way the Court of Criminal Appeals is now, and even our local courts of appeals, they don't want to reverse a verdict. It's that, oh, we need finality. I don't really care about finality. I don't care. I want it right? So So you have an absolute right to have a jury of nary shuffled upon timely demand. Do you all ever ask for that? Good. I like this. See, I'm thinking you all don't need to be here, and there might be some other people who should be here that aren't, because I can tell from you all that you're doing it right, and I appreciate that, but it's good to hear it again. All right. Judge's remarks. This is where there's some other, like, visiting judge, Jim Anderson, who will say some crazy stuff too. It's like a gold mine of nuttiness. I'm not kidding you. It's like on and on. So if you're not going to object, you're just letting all that go by. And you know what that tells the jury? Like, oh, well, your client is a bad dude because look how the judge is talking to him. So stand up, stand up. Object under 6th Amendment, Texas Constitution, all sorts of things that I have put in your paper for you to rely upon. They have, even little helpful information on this last line. Because I also am a big fan of case law, and I put a case or two for each little section in there. Because you know what happens when you bring a case to court? Yeah, they get nervous. Oh, you got some case law? Well, they got to call appellate. Well, right? Judge, I don't have time for appellate. I'm in the middle of trial. They should have been prepared for this. And I got my case, and I made you a case copy too, Judge, highlighted. Oh, Mr. DA, I guess you have Westlaw. You can look it up. I may make them a copy. But I just want you to be thinking about all of this. All right, states improper comments. Do they ever ask improper comments? Or ask improper questions or make remarks? Sure they do. They say crazy stuff too. Yeah, I won't say the name, but back in the day, oh, so sorry. Back in the day, like some old case, some of you might remember, like a DA went and slapped a defendant on the back and said, oh, he's a good old boy. Yeah, so that stuff happens. Was there any objection? I don't remember, a long time ago, but I know the defendant ended up losing. I do remember that. Okay, here's another, this is awesome. How many of you don't get enough time to voir dire? Just a few of you. The rest of you get all the time you need. I'm so happy. I would like you to have some questions ready when they shut you down. Say, Judge, I didn't get into this area, and this area. And you do know you're allowed to ask the same questions the state asked. You're allowed to, it's annoying to me when they want to talk about a defendant's Fifth Amendment right not to testify. Really? Shut up. You don't even care about that. Oh, I'm sorry. That's my inside voice. I haven't said a swear word yet like somebody who spoke before me because I'm keeping it toned down. Yeah. So you can write that in your evaluation. Well, she was very disrespectful to the prosecution, but she didn't swear. All right. Have some questions ready. And when the judge says, you're done, say, Judge, I just want to make this little bill of questions in areas I would have asked had I been given time. It's ready to go. You can have your list of questions. Cross them off if you get to them. Have 80 questions. I don't care. But they have to be relevant. They have to be not trying to prolong the process. If you put that in the record and you get the one-word verdict and one appellate attorney gets your record, they will probably take you to lunch too. That would be really awesome. So do that. You can do that easily, can't you? That could be part of your trial notebook, questions they're not going to let me ask, and I'm just going to make it a bill. All right, Judge, I get it. Yeah, I know, we're on time. I want to give a copy of this to the clerk and file it. You don't need to worry about it, right? Right. Because later on, we're coming back. Proper questions. Have they ever denied you the right to ask a proper question? Object. You're denying me the right to a fair trial, due process, jury. A question is proper if its purpose is to discover a juror's view on an issue applicable to the case. Question is proper if you can discover a reason to challenge that person for cause. Time limits we talked about, limitations in the record. Commitment questions. Do any of you get confused by commitment questions? Yeah, I do too. I'll admit it. We can all go drink later and sing about it. But here is what I want to tell you. If you think they've asked a commitment question, what are you going to do? Object. Even if you're not sure, because you know what happens if you're wrong? Nothing. Nothing. Right, nothing. But you've put them back on their heels a little bit. You've given your appellate attorney something to look at and think, well, I don't think that's a commitment question. But man, I'm really impressed with you for being on it. And if they want to, object to your commitment question, rephrase it, and then I'll come back later and say, hey, they weren't allowed to ask the question they should have been allowed to ask because it wasn't a commitment question. Yes? I'm sorry? So he asked, what if the commitment question is, can they be fair on a particular issue? Right, that's not a commitment question. So they object and say, you can't ask that because it's a commitment question. Well, Judge...
One rule that they go on board as a commitment question. Can they convict one witness rule? Which there isn't a one witness rule. What they use is a one witness rule. That's a commitment.
A commitment question is the one witness rule. Well, here's what I want you to think about. So you have a question and they say you can't ask it. I'd like to ask this question. State objects. That'll be sustained. So you can't ask your question. Have you preserved error?
Did you get the question out?
Yeah, you got the question out and they objected and it was sustained. You might want to say, well, Judge, I would like to add this violates due process and my client's right to a fair trial. But what happens if you make an objection? Let's say during closing argument, I object, they're striking at the defendant over the shoulders of the defense counsel. You've all seen that, right? That's basically when they say anything crappy about you. If you hear your